The next important selected leading case is the case number 16, that is Allen versus Flood. And in this case, the plaintiff was shipwright engaged by GI company to work on a ship from the day to day. The defendant, an official of the trade union of iron workers who were also engaged to work on the same ship, informed the GI company that the company should dismiss the plaintiff, who was non-union man, is not the man of his union, would cease to work, whereupon the company discharged the plaintiff. Therefore, the question for decision was whether the defendant was liable for maliciously injuring the plaintiff by inducing the employers to do something which it was lawful for the employers to refuse to enter into contract with plaintiff. It was held that no action lay merely to induce another to restrain from entering into a contract is not in itself an actionable wrong, though the motive may be malicious. And now we'll go to the next selected leading case, that is Chesmore versus Richards. In this case, the plaintiff was the owner of an ancient water mill. For more than 60 years, the occupiers of the mill had been using and enjoying the flow of a river for the working mill. The local board of health, whom the defendant represented, sank a well in their own land and pumped up a large quantities of water, with the result that the percolating underground water, which would have naturally found its way to the river and helped to work the plaintiff's mill, was obstructed, and with the diminution of water in the river, the plaintiff found it impossible to work his mill. The plaintiff sought to make the defendant liable, but the court held that the doing of an act otherwise lawful cannot give rise to an action in tort. However much it may be attended with loss to the party complaining, as the Privy Council pointed out in another important leading case, that is Rogers versus Rajendra Datta in 1861. It is essential to an action in tort the act complained of should under the circumstances be legally wrongful. As regards the party complaining, that is, it must prejudicially affect him some legal right. And now we'll go to the 18th important selected leading case, that is Mughal Steamship Company versus Mark Gregor. In this case, it is held down that no action for a conspiracy lies against persons who act in concert to damage another and do damage him, but who at the same time merely exercise their own rights by lawful means and who infringe no rights of the other people. The acts done by X and Y who acting in concert solely for the purpose of protecting and extending their trade and increasing their profits and which do not involve the employment of any means in themselves unlawful or not actionable, even though their acts cause damage to a. In other words, trade competition carried out to an extreme length is even though it causes damage to a not actionable provided that his competitors are acting solely with lawful objects of securing success in trade and use no unlawful means. And now we'll go to the 19th important selected leading case, and that is Gloucester Grammar School case. Thus, the defendant, a schoolmaster, set up a rival school next door to the plaintiffs, and boys from the plaintiff schools flocked to that of the defendant. It was held that no action lay, as no damage was caused by a rival in the exercise of the right to employ oneself in one's calling without let or hindrance and freely competing with one's rival in the same calling, but to stop the children from going to that school by waylaying or intimidating them is called illegal, and an action in that case would lie. And the last selected important leading case is Hadley versus Baxendale. Facts of the case: plaintiff was the owner of the mill. The mill had a broken crankshaft. The plaintiff delivered the shaft to the defendant, a common carrier, to take it to the manufacturer to make a new one. The defendant negligently delayed delivery of the shaft beyond a reasonable time. The mill was idle for a longer time. The plaintiff did not give understanding to defendant that the delay would result in the loss of plaintiff's profit. The plaintiff brought an action against the defendant for the loss of profit. The action was whether the defendant was liable towards the plaintiff. The defendant was not liable as it was held. As per the principle, when the contract is broken by the defendant, the plaintiff has right to file a case against the defendant for getting loss. The defendant is liable to pay the loss if the plaintiff suffers loss directly by the act of the defendant. Similarly, the defendant is liable to pay special damages to the plaintiff if he knows the special circumstances of the contract. So, in the above case, the defendant was not knowing the special circumstances, so was not liable to it. So, almost we have discussed 20 important selected leading cases from law, tort, And by this, we made completion of all these leading cases and their explanation and observation and the principles and the rules laid down why the English courts should show, why the Indian Supreme Court. And by this, we have completed the entire syllabus containing law of tort.